Okay, let's unpack this. So today we're diving deep, right, into the nitty-gritty of a local court in Uganda.
Yeah, the Chief Magistrates Court of Kibuku. We've got this fantastic set of judgments from one magistrate grade 1, Matanda Abubaker Hassan.
And this gives us, well, a really unique window, doesn't it? Not the big headline stuff.
Exactly. This is about the ground level. We're talking families, neighbors, these deep-seated fights over land, often going back decades.
Right. And the stakes feel so personal. I mean, we saw cases where land was swapped for, what was it, 2 goats and 80 shillings.
Incredible, isn't it? And now descendants are battling over burial plots or, whole cases getting tossed out on tiny technical points.
So that's our mission today, yeah. To tease out those patterns, the legal technicalities that actually decide who wins and who loses when these old histories meet formal law.
Precisely. It's about how justice operates right there at the community level.
Okay, Section 1, land disputes. It feels like almost everything revolves around land in these Kibuku cases.
It really does. Land is central. And the first thing that jumps out is just how old some of these conflicts are. We're looking at deals from the 80s, even earlier.
That must create legal nightmares, all that time passing.
It does. And the law has a very clear, if sometimes harsh answer, the time bar. Section 5 of the Limitation Act, Cap 80.
That's the 12-year rule, right?
That's the one. You basically have 12 years from when your right to recover the land first arises. After that, well, you're out of luck. Your claim is statute barred.
So even if you were definitely wronged, say, kicked off your land 30 years back, if you wait too long, the court just says, nope, too late.
Pretty much. The merits of the case, who was right or wrong back then, it almost becomes irrelevant. We saw that clearly in Mameka v. Nobeja.
Ah, yeah, the inheritance claim from 1980.
Right. The defendant claimed inheritance rights going back to 1980, but she only brought the claim over 30 years later. Dismissed. Time barred.
It seems tough, but I suppose it creates some kind of finality.
It does. Legal stability is the idea. We saw it again in Bulage v. Mula, the counterclaim about Dyson's estate. Same outcome. Too late.
And then there was Keddy versus Nacher. That one had layers.
Oh, absolutely. So first off, yes, the land claim itself, linked to a 1988 transaction, was time barred. 12-year limit kicked in.
But the judge went further, didn't he? Addressed the underlying reason for the transaction.
He did. He pointed out the land deal was tied to a bride price refund, and he made a point of saying that linking land sales to bride price refunds is actually unconstitutional.
Wow. So blocked by time, and the original basis was constitutionally questionable. That's quite a statement.
It really is. It shows the court trying to look beyond just the immediate dispute, maybe address some root causes of these long-running conflicts.
Okay, so time limits are a huge hurdle. What else trips people up in these old land deals?
Well, another big one is just basic confusion about what the deal was. Was it an outright sale, or was it more like a loan with the land as security, a mortgage?
Right, especially with informal agreements from way back, like in Bairaka versus Manuka.
Exactly. That case involved 80,000 shillings back in 95. The person who paid the money said sale. The person who owned the land said, no, it was a mortgage, security for the money.
And the court said?
Mortgage. It ruled it was an open-ended mortgage, so the original owner kept the land, in theory.
Okay, so a win for the landowner.
Sort of, but not quite. Here's the kicker. The court said, yes, it's a mortgage, so the plaintiff, who paid the money, has to give back possession. But the court also found that the plaintiff had trespassed while occupying the land during the dispute.
Oh, wait.
So the defendant, original owner, got the land back, had to repay the tiny 80,000 shilling mortgage sum, but was then ordered to pay the plaintiff 1.5 million shillings in damages for the plaintiff's trespass.
Good grief. They won ownership, but lost a pile of money because of how things played out.
That's it. Owning the land doesn't give you the right to just barge in if someone else is legally, even if temporarily, in possession. Procedure matters.
And procedure, or maybe just permission, was key in Loda versus Kabendo too, right? The case with the goats and the 80 shillings from 1975.
Ah, yes, the really old one. The owner sued her family members for trespass.
But she lost, even though she owned it.
She lost on the trespass claim because, crucially, the court found she had allowed them to use the land for years, for farming, building. There was even a hospital donation involved.
So permissive use, if you let someone use your land.
You can't suddenly turn around and sue them for trespass without formally revoking that permission first. Her entry wasn't unauthorized because she allowed it.
Fascinating. Okay, one more from this section. The family gift idea. The Jingo versus Kayendek. Mother versus daughter-in-law.
Right. The mother bought the land in 83. Her son lived there, built houses, passed away. Then the mother sued the son's widow, her daughter-in-law.
How did the court handle that? The mother owned the paper title.
It used the doctrine of gift inter vivos, a gift between living people. The court basically said, look, the mother still owns most of the 10 acres, but the specific part where the son built his houses, where he and other family members were buried, that bit was a valid gift from the mother to the son during his lifetime.
Meaning that specific patch became part of the son's estate.
Exactly. And therefore, the widow and children had rights to it. It's a way the court acknowledged the reality of family life, even when the formal title didn't quite match. It balanced the mother's ownership with the son's established home.
Okay, so surviving the time bar is just the first step. Then
Yep.
you hit these procedural traps.
Oh, absolutely. Getting past the 12-year limit just gets you into the courtroom. The next minefield is often pure procedure, paperwork, technicalities.
And the first big one sounds terrifying. The document trap. PID versus exhibit. Sounds like lawyer talk.
It is, but it's critical. PID means marked for identification. Let's take Boolage versus Mulo again. The plaintiffs had their land purchase agreements, signed documents from 93-2003. Key evidence, right?
I think so.
They showed them to the court. The court marked them PID-1, PID-2, but that's as far as it went. They never formally proved them and got them admitted as exhibits.
Wait, if the judge has the document, sees the signature, why isn't it evidence?
Because marking it for identification just means, okay, this document exists, it seems relevant, it has zero evidential weight until someone authenticates it. You need the person who wrote it or signed it or witnessed it to come to court, testify, yes, that's the document, that's my signature, and then formally ask the court to accept it as an exhibit.
And if you skip that step,
Your crucial evidence doesn't count. It's like it doesn't exist for the court's decision. The plaintiffs in Bullage failed entirely because their key documents were just PIDs, not exhibits.
that is brutal.
Yeah.
Years of fighting, maybe, and you lose because you didn't tick the right box in court.
It happens. Having the paper isn't enough. You have to prove the paper according to the rules. A very harsh lesson.
Okay, what's another trap?
Seeking the wrong remedy. Basically, asking the court to do something it can't do under the specific type of lawsuit you've filed. We saw this in Mbogo versus Ndobele.
The guy blocked from his land by neighbors.
Yeah. He sued them for trespass, which makes sense on the surface, and he asked the court for an order giving him access, a right-of-way.
Seems reasonable. If they're trespassing by blocking him.
But the court said no. Access rights, what lawyers call easements, or rights-of-way. They have specific legal pathways to be created. Through a contract, or proving absolute necessity or long use, or, importantly, through a specific application under the Raids Act to the minister.
So suing for trespass wasn't the right tool.
Exactly. He used the wrong legal mechanism. The court couldn't just grant him a right-of-way as part of a trespass judgment. He had a real problem, but he asked for the wrong solution under that lawsuit. He'd have to start over with a different kind of application.
Frustrating. And the last civil trap. Malicious prosecution.
Right. Salman Bashir versus Mabiyama Stephen. People were acquitted of assault charges. Then they turned around and sued the folks who reported them to the police.
Claiming the report was malicious, meant to harm them.
Yes. But proving malicious prosecution is really hard. The court looked at the facts and said, well, there was some kind of physical skirmish or fight. So because there was some basis for the report, the citizens who reported it had reasonable grounds to go to the police. And once they have reasonable grounds, their liability pretty much ends.
So even if the police maybe overreacted later or the prosecution went ahead weakly, that's not on the original reporter.
That's what the court found.
Yeah.
The responsibility for detention, for the decision to prosecute, that lies with the state authorities, the police, the prosecutor, not the citizen who made the initial report based on reasonable suspicion. It sets a high bar for suing someone who reports a potential crime.
That makes sense. It protects people reporting things in good faith. Okay, shifting gears a bit.
Yeah.
Let's talk about when other authorities get involved, like the RDC.
The resident district commissioner. Yes, that came up strongly in Limeka versus the Beja. The RDC had apparently stepped in and kicked the plaintiff off the land, putting the defendant in possession.
Which sounds like not their job.
Definitely not. And the magistrate used this case to make a broader point. It's called obiter dictum comments from the judge that aren't strictly necessary for the decision, but carry legal weight as guidance.
Like a judicial warning shot.
Exactly. The judgment went into detail about the RDC's actual constitutional role. Coordinating government functions, handling security. It explicitly said RDCs lack legal expertise, they must respect judicial independence under Article 128, and crucially, they have absolutely no power to issue or enforce eviction orders.
So a clear message about separation of powers. Keep out of court matters.
A very strong message. You need a court order for an eviction, full stop, not an RDC directive.
And this problem often crops up when land disputes get tangled with criminal law, right? Which brings us to the claim of right defense.
Yes, this is fundamental, especially in land cases that end up in criminal court. Take Uganda versus Gongobero. The charge was removing boundary markers.
Okay. Seems straightforwardly criminal.
But to be guilty of that crime, you need intent to defraud. The accused argued, hey, I wasn't defrauding anyone. I genuinely believe that land, including where the boundary marker was, belonged to me.
Ah, the claim of right. If you think it's yours.
You can't have the necessary criminal intent to defraud by asserting your ownership, even if you're mistaken about the boundary. The judge explicitly said this shows the danger of criminalizing land conflicts. These are civil disputes about ownership, not crimes.
And the same logic applied in Uganda versus Gamusi with criminal trespass.
Precisely. The accused entered land but claimed it belonged to his father. Because he entered under that belief, that claim of right, his entry wasn't considered unlawful with the intent to intimidate or annoy, which is what criminal trespass requires. Again, the court pushing back handled property disputes in civil court.
Okay, Section 4. Let's look at some purely criminal law distinctions the court had to make. First, domestic violence.
Yeah, Uganda versus Babu. Interesting because the couple wasn't married.
But it was still treated as domestic violence.
Yes. The court looked at the Domestic Violence Act, specifically Section 3(1)B. It covers relationships similar to a family relationship. And here, the evidence showed they had lived together, shared the same residence, and had a love affair.
So cohabitation plus romance was enough.
It was enough to establish the domestic relationship context under the Act, affording the victim its protections. It shows the law looks at the reality of the relationship, not just a marriage certificate.
Makes sense. Now, the really fine line. Grievous harm versus actual bodily harm. The ear-biting case, Uganda versus Nyonya.
Right. The accused bit off part of the victim's earlobe. The initial charge was the very serious one, causing grievous harm.
Which sounds about right, losing part of your ear.
You'd think so. But the court had to dissect the legal definition of grievous harm. It requires serious injury, permanent injury to health, or permanent functional disfigurement.
Functional disfigurement.
Yeah. The judge reasoned that while losing part of the earlobe was disfiguring, it was primarily cosmetic. It didn't affect her hearing. Her ear still functioned as an organ of hearing.
Wow. That's incredibly specific.
It is. Because it didn't meet that high threshold of affecting health or function, it wasn't legally grievous harm.
So what happened? Acquittal.
No. The court used something called the process of subtraction under the Magistrates Courts Act. The facts clearly proved some kind of assault that caused injury. So they convicted the accused of the lesser related offense, assault occasioning actual bodily harm.
That tiny distinction, cosmetic versus functional, changed the entire crime.
Completely. Different charge, different potential sentence. It highlights how crucial precise legal definitions are.
And finally, the slightly philosophical one is a grave property. From Uganda versus Gamusi again.
Right. The accused damaged a grave. He was charged with two things: trespassing on a burial place and malicious damage to property.
In the outcome.
Convicted of trespassing on a burial place. That section protects the sanctity of the gravesite, but acquitted of malicious damage to property.
Why? Is it a grave stuff? Earth? Maybe a headstone?
The judge questioned it. Does a grave fit the Penal Code's definition of property, something you can own, possess, use, dispose of? The court seemed to think, maybe not in that sense. The real harm was violating the burial site's special status, which the trespass charge covered. The property damage charge didn't quite fit the unique nature of a grave.
Okay, so stepping back from all these specific cases, what's the big picture from the Kibuku court?
I think it shows that local justice is incredibly reliant on procedure and precise legal definitions. Your deeply felt historical claim, it might mean very little if you missed the 12-year deadline.
Yeah, it's less about the emotion and more about the rule book.
Absolutely. Winning or losing can literally hinge on whether your lawyer knew to formally tender a document as an exhibit, or whether an injury affected function versus just appearance, or if the person you're accusing genuinely thought they had a right to be there.
It's a real look at how statutes and procedures interact with these long, tangled community histories. And often, the technical point wins.
It often does. Knowing the right legal path, the right definition, is frequently more powerful than having the seemingly stronger moral or historical case.
So here's something to chew on then, thinking about that Keddy versus Nature case.
The bride price one?
Yeah, the court said linking that land sale to a bride price refund was unconstitutional. Now, think about how much land, historically, across Uganda might have changed hands based on customary practices, maybe involving bride price or similar traditions, practices that might not square with modern constitutional law.
That's a really interesting point.
Could there be countless existing land situations, things people rely on today, based on deals done decades ago under customary law, that could potentially be challenged as unconstitutional if they ever got to court now?
That's a potentially massive implication. It suggests a lot of settled land arrangements might be resting on foundations that are, legally speaking, shakier than people realize.
Something to think about.
Definitely.
Okay, that's all the time we have for this deep dive. Thanks for joining us.
Thank you.